Can everyone hear me? Good evening, everyone. Oh, all right. Welcome once again to our mentorship class. This is the third week of the fourth quarter of our mentorship program. Like we are making so much progress. We've gone through the first week, through the second week, now we're in the third week. Slowly, we are coming towards the midpoint of this section. Please, you can kindly unmute your speaker. All right. So we'll just be diving straight into today's section, and I will just be taking a few announcements, and then we'll just get right into it. First and foremost, we'll be taking the announcement on registration. Registration is officially closed for this quarter, but you can still register for next. Q1 2024. Sorry about the noise in the background. Q1 2024. So if you have friends, colleagues who are still interested, who want to be mentored, who want to be trained in any aspects, including you, like if after this period, data protection and you want another, please, you want to pick up another course in data privacy and protection, you can just register with us. The courses available are still intellectual property, artificial intelligence and technology, the energy industry, fintech industry, health tech and law, patent drafting, blockchain, NFT and metaverse, data privacy and protection. So those are the courses that are available. If you, like I said, if you want to register for another course, you can reach out to me and we'll send you the link ahead of the first quarter of 2024. So there's still the opportunity for to register for the 30 minutes one-on-one mentorship section with your favorite mentor. We give that opportunity so that anything that you may want to learn more in details from your favorite mentor, you can get access to that through this channel. So you will get secrets, life lessons, directions from your favorite mentors. So this is what we are offering you in this particular, with this particular channel. So you can kindly reach out to me for more details. All right, moving to the introduction. Like we've had the first week, Mr. Emmanuel Ewere is back again with us this week for this section, and his profile is quite a lot to read, but I'll just try to read as much as I can, and we'll just move on to the next mentor. So Emmanuel Ewere is an accomplished information technology law specialist with a wealth of experience in guiding clients through the intricate legal landscape of technology, with over 8 years of expertise in the field. Over 8 years of expertise in the field, he has been a trusted advisor and on the various legal matters related to information technology, including data privacy, cybersecurity, intellectual property, and e-commerce. Education. Emmanuel has been has been a cornerstone of Emmanuel's professional journey. In 2015, he earned his call to bar certification from the Nigerian Law School, building a solid foundation in general law. He further honed his specialization in information technology law by pursuing a master's degree from the University of Tartu in Estonia. Prior to that, he completed his Bachelor of Law at the Maduna University in Nigeria. Emmanuel's career has been marked by significant accomplishments, and he has held key roles in prestigious organizations as a business developer at Flow World LLC in the United Arab Emirates. He managed various projects ensuring compliance and due diligence. He provided crucial counseling to his clients on matters such as data privacy, cybersecurity, intellectual property. Additionally, Emmanuel's skill in drafting contracts, conducting market research, and budgeting were instrumental in the driving the success of the various projects. Okay, if you want to get to know more about Mr. Emmanuel, you can kindly follow us on LinkedIn. His profile is on our LinkedIn page, so you can just read more. I don't want to just read out everything. So thank you. We'll be going next to, sorry. Oh, sorry. Our next mentor is Mr. Solomon Okidara. I seem not to have his profile over here, but let me look for it and then just read a bit of it. Okay, I'm coming. Please just give me a minute. Okay, we have lastly our last mentor for today, last but not least, Mr. Solomon Okidara. Solomon Okidara, barrister and solicitor of the Supreme Court of Nigeria, is a practicing legal practitioner and researcher with over 14 years post-call experience and outstanding expertise in human rights and a specialized and special bias for data rights, including data protection and privacy, data identity, online expression, intellectual property, e-commerce, tech and corporate transaction, and artificial intelligence, having an unusual knack for excellence and matchless client satisfaction with a view to delivering maximal results armed with a peerless ability to create legal research analysis, delivering impressive results in review of law, legal principles, and standard. Solomon is a partner at Solomon Okidara and Co., a firm of barristers and solicitors, and co-founder of Digital Rights Initiative, a not-for-profit NGO that focuses on promotion and protection of digital rights. Solomon is a strategic litigation lawyer with a robust interest and proven expertise in freedom of expression rights litigation. He has litigated on digital rights and freedom of expression subjects in courts across Nigeria up to the Supreme Court and has conducted cases at ECOWAS courts, amongst others. If you want to know more about Solomon Okidara, Mr. Solomon Okidara, you can follow us on LinkedIn and read the rest of his profile, follow through on the rest of his profile. Just about now, we'll be going into the business of the day. Okay, I'm here to see any of our mentors on call, and I'm sure they will be joining us very soon. But before that, I would just want to encourage our mentees to turn on their cameras, their videos rather, so that we can see their faces. And we'll just go straight into what we have for today. So can we have our mentees turn on their cameras? Please, we want to see your faces, want to know you. I'm sure some of you, if I do come across you on the road, I may not be necessarily able to recognize you. So please, if that is possible, you can turn on your camera. Thank you, Favor. Thank you, Churemi. Thank you, Chukwemeka. And okay, say while we wait for our mentors to join, okay, why don't we just go ahead and take presentations, the presentations that were made by the two groups. So we'll be taking it one by one. The copy has already been sent to the mentors, so I'm sure they've gone through it and they'll be giving their reviews while we wait for them. So please, if that's possible, can we have both group come and like make presentations while we wait for our mentors? Group one, you can come up stage and come and make your presentation. Okay, please, you guys ready?
Yes, we are. Good evening. Can you hear me?
Yes, I can hear you.
Okay, my name is Ubijak Chidera Precious, and I'm presenting for Group 1.
Okay, welcome, Precious. Thank you very much. Please, you can share your screen and start your presentation.
Okay. I'm just on that. Sorry, give me a minute. Sorry, it's taking so much time. I don't know why.
If that is taking, if that is not going to be possible, can we have, let's say, a group member, right, help you share your screen while, if you're finding it a bit difficult doing that?
Okay, that would be better, please. Thank you so much. That's if anyone is available.
Let me help you share the slide. Let me get it now.
Thank you very much.
Okay, is my screen visible?
Yes.
All right, you can go ahead and continue with your presentation. Hello, can you hear me?
Sorry. Yeah, I can hear you. Sorry, I'm so sorry, but this is not looking like our work.
Okay. Oh, sorry. I accessed the wrong thing. Let me look for yours. Okay, can you hear me?
Okay, yeah, this is it. Sorry. Thank you. So if I can continue.
Yes, you can go ahead.
Okay. So like I said earlier, I'm presenting for Group 1, and our topic is centered on overview of data subject rights. So particularly data subject rights are a set of legal protections and privileges granted to individuals regarding their personal data. And there are various types of rights. We have the rights over automation, right to object, right to data portability, right to restrict processing, right to rectification, right to erasure, right of access, and right to be informed. We have the legal and regulatory framework. So now we have the local laws, which are the national laws. We have the international laws. They're listed here. We have the general data protection regulation and the rest of them. So talking about the types of rights, the first one, which I mentioned, right to access, is provided for in Article 15 of the GDPR, which allows individuals, that's the data subject, to obtain information from the organization, which can also be referred to as data controller, about whether their data is being processed, and if so, what is, or the purpose of the processing, the categories of processed personal data, the recipient to whom the personal data have been or will be disclosed, for what period will data be stored. That's the retention period. We have conditions for exercising the right to erasure. I'm sorry, I skipped the first page. The page before these conditions. Can we go back a bit? It's a bit blurry. I didn't get the first 2 or 3 sentences above. So we have conditions for exercising right to erasure. So we have section 30 for sub 2 under the NPDA. And section Article 4, we have where the personal data is no longer necessary. These are the conditions in relation to the purposes for which it was collected or processed, where the data controller has no other lawful basis to retain the personal data. Then under Article 17, we have where the data subject withdraws consent on which the processing is based, where the data subject objects to the process, where the data subject objects to the processing, where the personal data has been unlawfully processed. So these are the conditions. Okay, so we have a case law here, the EUCJ decision in the landmark case of Google and CNIL, which establishes the non-absolute nature of the right of erasure by ruling that such right can only be exercised within the territorial scope of the law that grants it. We also have other cases here. We have the NTI and NT2 and against Google and the rest of them. We have circumstances where data subject rights to erasure can be overridden under the GDPR. And we have that it's provided in Article 17, sub 3. And they include one, the data it's being used to exercise the right of freedom of expression and information. It's being used to comply with a legal ruling or obligation. It's being used to perform a task that is being carried out in the public interest or when exercising an organization's official authority. It's being processed. It's necessary for public health purposes and serves in the public interest. We have also the right to portability. GDPR defines the right to data portability as the right to receive data processed on the basis of contract or consent and processed by automated means in a structured, commonly used and machine format, and to transmit that data to another controller without hindrance. Data subjects has the right to transmit personal data from one data controller to another without hindrance from the data controller. We can see this evident in Article 12, 2028 of the GDPR, and also Section 38 of NDPA. Also have Section 1, sub 3, paragraph 6, if I'm not mistaken, and the rest of them as listed there, please. So we have right to object, Both the MPDR and GDPR provides for the right of data objects, the right to ask organizations to cease the processing and sale of the personal data. The right to object to direct marketing is an absolute right. The right to restrict processing include an exception for where the controller demonstrates compelling legitimate grounds for the processing that overrides the rights and interests of the data subject. We have time frame to respond to the objection to processing of data. The NDPR requires the deletion of data without undue delay. The NGDP explicitly provides for the time frame of 1 month with the possibility for an extension of 2 months. These are enforced in the various articles of GDPR. Automated decision-making profiling rights. This refers to the automatic processing of personal data done without human intervention and where it produces legal consequences affecting the data subjects. Profiling is the automated processing of personal data for evaluation of personal aspects of an individual or data subject. Prevention of automated decision-making is regulated under Section 37 of the NDPA and NDPR. The prevention of automated decision-making, but Article 2.2 of the NDPR prohibits all forms of unlawful processing of personal data. Advocate General opinion in case, there are actually cases backing up the points above. We also have in Article 22 of NGDPR, where automated decision-making and profiling is prohibited, but only permitted where express consent is given, necessary to perform a contract under your lawful authority or for substantial public interest. This is also seen in Article 22, sub 2 of GDPR, particularly sub 2. See also Section 9 of the California Privacy Rights Act. Now we have responsibilities of data controller and data processors. One is compliance with the law. Example of these laws are adopting and implementing comprehensive data protection policies, recording of processing activities, keep record of their processing activities in writing, also safeguarding integrity and confidentiality of data. That's to ensure the protection of the integrity, infrastructure of the data in their possession, report and investigate data breach. Also have conduct data protection, impactment assessment. DPIA, prior to processing personal data, Article 2235 of GDPR, see also Section 28 of NDPA. We have appointment of data protection officers. They're meant to appoint data officers and give them defined responsibilities, especially in regard to compliance with data protection regulation. We have more responsibilities of data processor and controller. They include that they must ensure that the DPO is provided with adequate power, autonomy, and resources to undertake that responsibility. Article 35
Sorry, the person whose speaker is please
Can I continue? Okay, thank you very much. And I mentioned they also have to ensure that the DPO is provided with adequate power, autonomy, and resources to undertake their responsibilities. This is provided for in Article 35, sub 2, 36, 3 part D, 37, 38, and 39 of GDPR. Also in Section 8, sub 9 of Digital Personal Data Protection. That's particularly in India. They also have the responsibility to notify a breach. We have procedures for handling data subject requests. Now, these are the challenges in implementing data subject rights. These challenges include, but not limited to, compliance, regulations, different requirements for various rights, data volume and sources, accessing data out of the numerous databases, data security, that's ensuring that the data is secure, can be very challenging. Timely responses. Data request process is time-bound, even when there is robust request. Data accuracy. Ensuring that data is provided to the data subject is up to date and accurate, can also be challenging. Best practices to ensure compliance with data subject rights. First one is enhanced privacy protection, which could mean, sorry, I've lost you. I think we've lost you, Mr. Dennis. Hello? Hello? We're still here? Okay, I think we've lost Mr. Dennis. I don't know if Francis, can you please help us? If you can, let me see if I can share it now. I'm having issues with my storage. Yes, please. Jeremy, please. Thank you.
Sorry about that. I had a little network issue. Thank you.
So who is sharing now? Mr. Francis.
Hello, can you see my screen?
Yes, I can see your screen, but we're yet to get to the documents to see the slides. Okay. I think we are now waiting for Mr. Chuomi. I'm still waiting. Who is sharing? Okay.
Okay, can you see my screen now?
Yes, I can see your screen. I can see it. Thank you.
Okay, so what slide are you on?
Let's check.
Are you done with procedures for handling data subject requests?
No.
Okay.
I think we stopped at challenges.
These are the issues.
Done this, yeah. No, I think we should enter this. We just finished challenges. Yes. Yeah, we've done this one. Yeah.
Is it after this?
After this, yes.
Okay.
All right, thank you. Please, are we together now? Can I proceed?
Oh, okay. Yes, you can proceed.
Okay, thank you very much. So we have impact of implementing data subject rights. The first one is enhanced privacy protection, which is to ensure that individuals have control over their personal information, protecting privacy and data security. The next one is improved customer trust, which fosters trust between individuals and organizations, demonstrating a commitment to ethical data handling and respect for privacy. And the next one is empowered individuals. Granting data subject rights empowers individuals to access, correct, and control their data, giving them a say in how their information is used. We have global data transfer facilitation, which aids in seamless international data transfers. Other impacts include innovation and research, efficient data management, transparent business practices, risk mitigation. Thank you. Next slide, please. Okay, we have cases that illustrate data subjects enforcement. We have national laws and foreign cases. We have the Incorporated Trust Pedigree Initiative for Information. Can you please blank? Something is blocking the cases. Yes, thank you. Okay, let's go. I think we've taken enough time here. We have national law cases and foreign cases which have been listed here. That's okay. Oh, okay, that's all. And these are the numbers. Thank you so much for listening. And I'm sorry for taking so much time and the whole delay. We apologize. Thank you.
All right.
Sorry?
There's a lot of noise in your background. Thank you. Okay. Sorry again once for the small brief in transmission from my own end. Network issues. I'm sorry about that once again. And we are still waiting for our mentors to join us. So while we wait for them to join, can we have Group 2 make their presentation? Please, in a case where I'm not able to share, please, can we have someone who is on standby for Group 2 to help share the screen so that we don't have to go around the whole issues around sharing and the delays. So please, can someone be on standby in case if the presenter is not able to share the screen, to share their screen? So please, can Group 2 come up stage and make their presentation? And Group 2, we're waiting for you. Can you come up and make your presentation? Is if the presenter is not available, can the backup presenter come up and make their presentation on their behalf? Anybody from group 2 that is on call?
I'll be with you in a minute.
Hello.
Yeah.
Sorry, am I audible?
Yes, you are.
Oh, okay. So I'm Oluwagbinga Michael Ade. Good afternoon, everyone. I'll be presenting for group 2.
Thank you, Binga. You can go ahead.
Okay. All right, just need to set up properly. So can everybody see my screen? Can everybody see my screen?
Yes, we can.
Okay, all right. Just need to make it good. All right. So group 2 was assigned the topic, and our topic is data subject rights, the right to access, rectify, and delete personal data, the right to object and restrict possession. It was a collective effort, and here's our presentation. So just to have a glimpse of the table of contents. During the discussion, we'll be going through introduction to data subject rights, all the way to types of data subject rights, overview of right to access, overview of right to delete personal data, and also we'll branch on to overview of right to object, right to restrict data, violation of data subject rights and legal remedies for data subjects, and case study on data subject rights, and then we'll conclude. So that's just the flow of the presentation. Now, to have a feel of what we are discussing today, we need to understand what data subject rights are. But before that, we should understand who a data subject is. I think most of us here should be conversant with the fact that a data subject is typically a person that can be identified, that has a certain means of identifying that person. As we all know, data is life in the current era, right? So this means that a data subject is one who, by his personal data, he can be identified, singled out from the masses. Our data is what should I call it, a distinguishing element, for us all. So that is typically who a data subject is. So now when we talk about data subject rights, we're talking about the rights of a data subject. It's commonplace to see people's rights, privileges being infringed upon. It's a common notion in law that where one man's rights begins is where another person's rights ends, right? So there is bound to be a confluence. Now, the subject of that confluence is the data subject's rights. And as can be seen, we presented a case here: emerging market telecommunications services, and Barrister Godfrey Inya NA. It was a case that this case actually is one of the pivotal cases that showed the necessity of having a unified law, regulation for data privacy. So now let's move on to the next point. Now the question is, what are the rights of a data subject, right? The rights of a data subject. As can be seen in the presentation before us, Section 35 is crystal clear, in fact, on the rights that can be accrued by a data subject. Within the section, the Act was able to show us that a data subject has rights to obtain from a data controller without consent or unreasonable delay, confirmation on the storing and processing of personal data related to the data subject. So here we're talking about retrieval of data, personal data from a data controller. Furthermore, we are seeing here that the data subject's personal data in a commonly used electronic format, except where it will produce unreasonable cost to the data controller, in which case the data subject is required to bear some or all of the cost, the correction or deletion of the data subject's personal data that is inaccurate or misleading without undue delay. Here we're talking about retrieval of personal data and also deletion, or removal of such data. That is at the request, beck and call of the data subject. So Section 35 gave us a glimpse of, some of the rights that a data subject has. But one should note that that section, it didn't go into specifics, right? It just gave us an overview. But then one can always get the proper rights from subsections of the Nigerian Data Protection Regulation, and the Nigerian Data Protection Act 2023. First right that we'll consider is the right to be informed. Now, the right to be informed is, should I call it, is part and parcel with the right to access to information, right? So it would be unwise for a data controller to wield a person's data freely and not be accountable for such data, that is to the data subject. As can be seen here in the presentation, section 2.3 here, of 1, of the Nigerian Data Protection Regulation 2019 explains that the data subject is vested with the right to know what personal data is collected about them. We have vivid examples of such of websites, applications, and all complying with this particular this bit of regulation. If some of us have been able to peruse the terms and conditions of certain websites or applications, we would see that it's vividly explained there that if this data is going to be shared with third parties and all, you'll be informed, or they will tell you exactly what they will use your data for. Because without a clear and concise explanation of where the data goes, because data, as I said, is life, it would be detrimental to the data subject, right? So the data subject has the right to information on how his or her data is being used. Next is the right to access. Here it says that data subjects are allowed to be informed, to even request for a copy about the processing of their personal data, the categories of personal data involved, the recipients or categories of recipients to whom the data has been or will be disclosed, and the envisaged retention period. This particular factor, right, which is also a right, but this particular factor was in contention with this. I don't know how many of us are conversant with the OpenAI controversy. Now, the OpenAI controversy, what happened was that if you go through OpenAI, that's the ChatGPT provider that I am sure we're all conversant with. So if you go through the terms and conditions, yes, specifically on the use of data, it was stated there that users will not be able to determine where their data will be used. They said, and I quote, that the data can be used for third-party interactions, third-party businesses that will not be made clear to the user. Interestingly, this clause, I like to call it, was a rather sketchy one, and it led to a lot of repulsion from international organizations, right? So this just goes to show that it's very vital. It's a very vital right to access, right to be informed. And furthermore, we had the right to rectification. Yes, right to rectification, like I said, the data is a distinguishing factor in this era, yeah? So when we have pieces of data that are inaccurate, that are not, that are subpar, let me put it that way, it would reflect certain levels of misinformation about data subjects. As such, data subject has the right to call for rectification. It's just like you need to change your phone number, for instance, in a register. For instance, you want to change your phone number for NIN, go to NIMC, that's the body in charge of generating our national identification numbers, and then you correct your phone number to reflect that, okay, I've changed my phone number, former one was defective or it's not in use, then you can rectify it. So these key rights, for starters. Sorry, I would like to know, are you guys following, is everyone following me? I don't just want to keep going.
Yes, right.
Okay, thank you. Okay, I'll just pick two more rights from the ones that are written here, so I wouldn't waste too much time because I know we're working on time. Okay, so yeah, the next one is the right to be forgotten. This is also in line with the right to rectification, right? You as a data subject, you have the right to pull down, data that is relating to you. Like I said, I gave the instance of your phone number. It would be, I wouldn't say catastrophic, right? But for instance, if you have an old phone number and a new phone number connected to your, your national identification number, right? It would be it doesn't make sense to have dual, numbers on that register. As such, you can call for that phone number to be taken down, from the database. So that's just the idea of right to be forgotten. And it goes beyond this, really. It goes beyond this. You can have data that you don't. Interestingly, data never really, data can't really be obliterated, right? But it can be exempted. I don't know how to put this, but there are always strands, right? Strands of data strung out across the.
Okay, Michael, are you still available? We can't hear you.
Apologies. Sorry, I noticed that there was noise coming, so I had to change location. Is this? Can you guys hear me properly? And I hope nothing is interfering from the back. Can you hear me?
Yes, we can.
All right. So finally, before I move on, I'll just touch on. You can hear me, right?
Yes.
Okay, all right. I'll just touch on the right to speak processing. It would have been perfect if I had categorized them into positive and negative rights, right, from the onset. That way, I would have been able to cover all of it in its entirety. But rights like right to be forgotten, right to restrict possession, rights to removal, and all those things, they are more like negative, right? It just involves the data subject requesting. It has this negative tone to it, right? So right to restrict processing is just stopping how do I put it, from stopping a one who has access to your data, right, from using it any further. That's just the idea. That's just the idea. So it's, like I said, it's in line. It's more of a negative right. Let's go on. There's no time. Let's go on. So now, briefly, let's just gloss through the overview of rights to access. Now, I think you can see that here. It says that by virtue of Section 34 of the NDPR, right, the right to access gives the data subject the right to obtain without consent, unreasonable delay, relevant information of its personal data, and how it is being used. Do you get? So this is this just shows that once your data is at your beck and call, since it's a personal effect, even though it's intangible, right? So it's all you need to do is call for it, and then the data controller is what word would I use for that, for this, is expected or obliged to provide such data, and then it says here that how do we recognize subject access request? Now, a data subject shall be verbally or shall verbally or in writing make such request. So it can be a mail, can be, just expressed in one way or the other. Just ask and it shall be given to you, honestly. So it says here that a data subject may be represented by a third party, that is in proxy, or if the data subject is a minor, for instance, you can have, something like locus parental or what have you to represent that data subject, just to, should I say, effect or put the right into action, enforcement of right and all. And there are certain situations, yes, where the right to access can be denied. We've covered why, we've covered the fact that data subjects typically they have the right to access, right? So, but then this right to access is not unfettered, it's not absolute. There's certain instances where it can be denied or they might not be able to enforce such rights. First is public interest. This public interest factor, it spans across many aspects of enforcement of rights and not even just under data privacy. Now, what happens here is that the way they try to juxtapose the data subject's request, right, or the enforcement of his rights with the interest of the public, where the interest of the public is seen to weigh, let me put it that way, weighs more than the result that will be from the eventual upholding of data subjects' rights. It will be, it's that one will supersede the other. Do you understand? And this was encapsulated within Section 37 of the Constitution of the Federal Republic of Nigeria. Like I said, where a person's enforcement of a person's rights, when juxtaposed with public interest, will show whether public interest will supersede the other. Yeah, and then it says here that also where such restriction is for the sole interest of data subject, Section 36 sub 2 of the NDPA, applies. Now let's move on. Time, finger. Okay. Next, we have the issuance of cost to process data subjects requests. Like we said earlier, that I don't know if you were flowing with me, but I mentioned that where such data is called for and the issue of cost comes up, that is the cost of retrieving or providing such data to data subjects is like it was stated here, a roadblock. You know, Section 34 of the NDP says that the data subjects may maybe I won't say forced, but may be required to pay a part payment, for the retrieval of the information, or maybe made to bear the full cost. That is if the data provider, it's beyond the data provider to provide to cover cost, since it's a data subject's request. Think of it like you're trying to make a transfer, right? And then it's normal that when you make a transfer, probably USSD or what have you, you must pay transfer charges. Let's put it that way. So typically your money is in the bank, but you have to cover the costs for transfers. You can't expect the bank to just transfer your money and then, that way the bank will be making any money anyway. So you would have to cover the cost for transfers, even if your bank offers subsidized rates and all, but still you have to cover some level of cost. And this was, this was explained in Data Rights Lawyers Initiative and Digital Rights Lawyers Initiative, that's Mr. Solomon Kedara's organization, and NIMC, So, and also there's, of course, the restriction by any statute or existing regulation that will also, bring about the necessity of paying the cost for retrieving data, and also where such information is needed for investigative purposes by any of the recognized and registered enforcement agencies. Like I said, data is connected with our lives and all. So we need, when for instance, the police, FBI, whatever, they have to use that data to, probably identify, investigate, they might have to pay for you to get the data, because without payment, it might not be given freely. Let's move on to the right to rectify. Are you guys following, please?
Yes, we are. But if you can you up or speed up the presentation?
All right. That's fine. Okay. So now the right to rectify. Like I said, data can't be easily obliterated, right? So sometimes all we need is to edit. Let me put it simply, to edit data. Like I said, the data subject is vested with the right to call for rectification of data, because inaccuracies in data can affect representation. Let me put it that way. So just to simplify things. So the data controller must, upon request, rectify such data. You can check the case of Incorporated Trustees of Laws and Rights Awareness Initiative and National Identity Management Commission, that's the NIMC. And next, the right to delete personal data, also in line with the right to rectify, but it's more inclined to obliteration, So this just says that, where there is erroneous data out there in a database, the person has the right to forget, such data. And you can see this in section 34, so 34C of the NDPA, So the data subject at will, or, when necessary, don't let me say at will, because you can't just call for deletion when there is nothing wrong. So he has the right to delete his personal data where he feels like it is not a perfect reflection of what it ought to be. Then furthermore, it should be noted that Section 36 of the NDPE, clearly shows that the data subject, can do all of these things, right to object. And like I said, in instances of public interest or any other legitimate grounds which overrides the data subject's fundamental rights and freedoms, general national census, investigation by government agencies, etc. So I didn't even really mention the right to object. So I feel like I shouldn't fix it on that for long. Where else? Okay, this is the right to restrict data. Has to be fast. Okay, yeah. So violation of data subjects' rights and legal remedies for data subjects. We've mentioned that in as much as their rights, there is a possibility of infringement. So where such occurs, Section 36 of the Data Protection Act covers it, So it just says that infringement of the provisions of the Act or any relevant subsidiary legislation attracts appropriate orders by the Commission, where to satisfy that a data controller or data processor has violated or is likely to violate any requirement under the Act or the subsidiary legislation. So this just covers infringement, and then the legal remedies that we have. It says here that it may make enforcement orders, that is the Commission, right, where it is satisfied that a data controller or data processor has violated the provisions of the Act. A person who is not satisfied with an order of the Commission may apply to a court of competent jurisdiction for judicial review within 30 days after the order was made. So it just shows here that first, the Commission is the first point of access to the data subject. If the data subject order, right, is not effective, it is not final, it's not the final point. So such a data subject can still sort of appeal, so to say, but it's just the first point of access to the court. It's commonplace that the court is the last resort of the common man. Let me go through this. Okay, let me just go to the case study on data subject rights. Okay, so some of these cases we've mentioned it, I mentioned it in the previous slides. First is the Incorporated Trustees of Digital Rights Lawyers Initiative and NIMC. It says here that the claimant instituted an action for breach of his fundamental right to privacy and family life, thereby upholding the provisions of Section 37 of the Constitution. The court held that the provision of right to privacy hadn't been breached as the claimant had failed to institute the suit at the right court, and considering the facts and elements of this case, it had also refused to understand that the sum of 15,000 naira was an administrative fee meant to be paid to the federal government for rectification of his data, which in line was in compliance with the NDPL. So this particular case was concerned with data retrieval, and what was one of the issues that was in contention was the payment of the fee, whether it was legal, right? And it says here that that fee, as I explained earlier, that one of the limitations to asking and retrieving data is payment of fee, right? And sometimes the data subject will have to, take responsibility for the fees of retrieving data. That is, if it is not agreed upon by the data processor or data controller, that in situations where data is to be retrieved, that he will bear the cost. That's the data controller will also bear the cost. So typically, data subject will have to weigh in where such is required. And finally, the other case, Emerging Market Telecommunication Services and Barrister Godfrey Inya Eneye. Briefly, let me just cover what they said. In the case, Mr. Eneye, a legal practitioner, sued the operators of Etisalat mobile line for exposing his telephone number to persons or companies which sent him unsolicited text messages in violation of Section 37 of the Constitution. The Federal High Court awarded him damages of 8 million naira. On appeal, the court reviewed the provision of Section 37 and 39 of the Constitution of the Federal Republic of Nigeria and still upheld provisions of the Federal High Court. Now, I think we have all been, most of us have been victims of these telecom, companies sending numbers across for unsolicited SMS messages and all the likes. So this particular man sued, Etisalat for this misdoing, I'll put it that way, and he was compensated, because he probably explained, he definitely explained his grievances, and the case was upheld. Even upon appeal, it was upheld. So what I'll say is that, just to conclude things, is that data subjects, the data subjects and the rights of data subjects are heavily connected with right to freedom of information, right to privacy in particular, and right to privacy and family life, all those things. So it's in line with the Constitution, the constitutional provisions of these rights, right? So typically, what the Constitution provides for, although I won't say it verbatim because I can't say it verbatim now, is that these rights, that is person's correspondence, and all those things are fall in rights category, they are to be protected, right? But it doesn't go further to, like, it doesn't compound things in such a way that the full effect of data privacy will be achieved by the Constitution. And I feel like that is what necessitated the enactment, promulgation of these acts, right? Or this regulation and act, So it just goes to show that in this era, this is a technological era, by the way, it is necessary, right, to enforce the data subject's rights, to preserve these rights, and definitely this area of law, right, even though it's still developing, it will become solidified in years to come. And I hope that this presentation was, it met your expectations. And I guess it's time for questions and answers. Do we have questions, please?
Okay, we'll be taking questions after our mentors are on call. I can see both Mr. Solomon and Mr. Emmanuel are now here with us. So we'll be giving them an opportunity to have their sections before we now take questions. So thank you, Mr. Michael, for helping us through with that presentation on data subject rights. It was well detailed and there was a lot of information in there. So we'll be having our first mentor for today, Mr. Solomon Okidara, to come and just do due justice to that subject, and then we'll have Mr. Emmanuel also come and give us a bit of all informations in that direction. So, Mr. Solomon, sir, this floor is yours.
Okay, thank you very much. Should I stop sharing the screen for now?
Yes, you can stop sharing your screen.
Okay, thank you, everyone.
Can you hear me? Hello?
Yes, sir, we can hear you.
Oh, excellent. So, good evening, everyone.
Yeah, good evening, sir.
Chief Emmanuel is in the house. Okay, Emmanuel. Is he on the call?
Mr. Solomon, my big pleasure to have you today. It's been a while.
How are you, sir?
I'm good. I'm excellent.
Great. Maybe I will get in touch with you. I think within the next 4 months or so, I think I should just stop by at your Domox. Let's see.
That would be great.
Let me feed from those things you are feeding on. It's all right. Okay, so good evening, gentlemen.
Good evening.
Okay, great, great, great. So yes, well, I think if anything, I picked the fact that this particular set showed me that that they can respond to or adjust, and respond positively when corrected or when properly corrected. So I realized that the two slides are sent to me. Efforts were made to actually reflect case law, and I think that's quite commendable. Can I get a round of applause for the two groups to start with? Okay, great, great, great. So okay, so yes, well, I've actually followed through the presentations. Fair enough, though there are still some discussions that were quite scanty and empty. Empty because, you see, when I keep emphasizing the essence of case law, you see, whether the decision was whether it expanded the principle of law we are discussing, or it contracts it or negates it, helps us understand, how the court has applied it, either rightly or wrongly. So, for example, I actually saw right to be forgotten, and I'm sure none of the two groups cited any authority on right to be forgotten. Is that correct? Is there anybody any group that cited a case law on the right to be forgotten? I know Genga's group didn't cite the case law. Genga, am I correct?
Yes, sir. Yes, sir.
The other group, did you cite any authority? So the other group is not here.
Group 1, were there any citations on the right to be forgotten?
Did you cite any case law, group 1?
Seems like group 1.
Yes, we did, sir.
So what authority? I'm waiting. What case, please? Maybe I should check your presentations for you.
All right, sir. We cited a European Court of Justice case under the right to erasure, which is also the right to forgotten. We cited the case of Google and CNIL. And also we cited the case of NTI and NT2 and Google, where an ex-convict who wanted his criminal history to be brought down from a news outlet that published it. So the court ruled that that would not be the case because his criminal history still remains relevant and he cannot exercise his rights to erasure in that instance.
Okay, fair enough. You just want yourself a dinner, which will be taken care of by group 2. I think Binga should make that sacrifice on behalf of group.
So is that enforceable? Is that judgment enforceable, sir? So that it's not being in vacuum.
I'm even preempting this court. This court hasn't actually finished with some others. There are some clarifications. Now that dinner will be proteinless. And I'll tell you why it will be proteinless. It will be proteinless because there is at least one known Nigerian case law on right to be forgotten as of today. At least one. So that's why your dinner is going to be proteinless. So after the session, you can meet with the group leader or presenter of group 2 and see what Benga, you're at liberty to decide what is dinner. This court has not limited you on what constitutes a dinner in this instance. a cup of garri can be dinner.
Mm.
Even those.
So we're fasting. We're fasting, sir.
Who is fasting? Group
We
one or
will
group,
fast.
group one?
Yes.
Oh, well, okay. So you forfeit your right. Okay, so the two groups, there's a fundamental mission. Group two tried, around to move around, dance around it, but you guys would have done better by hitting the nail on the head. Now, it's okay. You have actually talked about the data subject right. Essentially, the NDPA, makes such a provision quite expansive for it in section 36. But then, section 3.2 of the NDPA makes a very fundamental position on data subject right. That is the section that says, look, in these instances, to hell with data subject right. Now, so for whatever reason, whether you're advising a client, or you are consulting, or you want to litigate, one of the fundamental things you need to do is to, first of all, when you're talking about right, first of all, check those exemptions. I hope our matter does not fall under any of these exceptions, provided in section 3, subsection 2A to E of the NDP. Now, like I said, I realized that group 2 danced, the whole lot danced for some time around it, but dancing at the gate of the hall is not the same thing as entering the hall to dance and win some trophy. So we really need to look at it. And for all anybody cares, I think the only thing I'm going to focus on is to have us look at that section 3, subsection 2, A to B. Or I'm ready to be proved wrong. Do we have any of the group that discuss that section 3, subsection 2? Did any of the group discuss it really? If you do, I think you might win a dinner from me. Any of the groups?
Sorry, sir. I didn't quite get what you said, sir.
I said essentially section 3, subsection 2A to E of the NDP essentially makes us to understand the applicability of data subject right, particularly circumstances where they are applicable or circumstances where they are exempted. And I'm saying whether you are consulting, advising a client, about to litigate, when a matter comes to your table, the very first thing you may want to do is to check out whether all of this, the particular matter where your client is about to exercise his data subject right, does not fall within any of the exemptions. Let me first of all ask us, are all rights absolute? Or are there some rights that are absolute or some rights are not absolute? I mean, let's just ask ourselves that question as lawyers and students of law. Are all rights absolute? Are there some rights that are absolute, some rights are not absolute? Can we discuss that briefly?
Hello, sir.
Yes.
I think certain rights are not absolute. They have some form of limitation. Let me give an instance. If you look at the fundamental human rights,
your voice is low, Michael.
Okay, can you hear me now, sir?
It's a bit better, but you can be louder.
Okay, sir. But can you hear me now very well?
Yeah, very well. Thank you.
I said, some certain rights are not absolute. There are certain limitations placed on those rights. And I was making reference to the fundamental human rights.
Okay.
Yes, so if you look at section 40 of the Constitution, It derogates, or it provides that, in some certain circumstances, a person cannot complain that, his particular rights, in respect of human rights, are not violated under specified circumstances. So under those circumstances, the person cannot complain that his or her rights has been breached in respect to, like, security, in terms of public policy.
Okay, which rights are absolute?
Actually, I think no rights are absolute. They have some form of control over them. It's either there are certain laws, limiting the person's right, because if you say that rights should be absolute, I think it can extend to something that, a person's right can actually, go beyond his own rights and step on other person's rights. So all rights are not absolute. They have some form of control or limitation.
Michael,
Sir?
you have some dancing skills too. So you are also just like Benga. You have an idea, but you are at best dancing. I need you to enter the main hall so that you can get your trophy. Because if you dance for too long at the entrance, we'll actually rather have the security guys to take you. Get ready.
So all rights are not absolute, sir.
Okay. Churemi, yes. Good to have you. Listen.
Okay, good evening. Can you hear me?
Yes, I can hear you.
I believe no right is absolute, because the right is going to be conferred by the government. In our case, is the Constitution. And so, as Michael mentioned, the fundamental rights captured in Chapter 4, Section 45 puts restriction and conditions for which they can be derogated.
Okay.
And it is these conditions now that apply severally according to what the government, which is public interest and all that. That's what makes these rights not absolute.
And Churemi is moving towards the hall, but he's still a dancer too. He's still dancing. That skill actually took him a little step or some steps, ahead of Michael, So he mentioned Section 45. So if you check Solomon Kidara and Natongera of the prohibition, in that case, the applicants or the appellant now, because it was a court of appeal decision, challenged, the provision of Section 24(1)(b) of the Cybercrime Act. And he is saying, look, this section is broad. Its provisions are broad, vague, and ambiguous. So, and he said, look, it actually hurts fundamental right to freedom of expression. And of course, the appellant quickly argued that, yes, I know that this right, like any other right, is not absolute and can only be limited or restricted by provisions of Section 45 of the 1999 Constitution that provide that this right can be limited by a law that is reasonably justifiable in a democratic society. I love that provision, particularly the couching of this right. And it then goes further to say, look, the first thing you need to know is that it has to be by a law, not a directive. Now, there's a particular case, and why I would love to focus on this is because now, even without you citing case law, almost everybody in the room now, you have an idea of those rights. Is that correct? The data subject right. Is that correct? Can you hear me?
Yes, sir. Yes, sir.
Now, but Section 3, subsection 2(a)(e) are saying, look, these rights contained under this law, they can be exempted subject to the provisions of the Constitution of Chapter 4 and provision of Section 3, subsection 2(a)(e). Now, as a matter of fact, it's made first reference, early reference, in fact, prior reference to the Constitution. So that's why we need to focus on that. So I have given these examples a good number of times, and I love to give it, again and again. The case of Abdul Latif and Lagos State government and Abdul Latif. It was a case where a Muslim couple was stopped from coming to school in hijab, a public school. Now, the school authorities citing the fact that the school is a public school. It has its own dress code laid down by the school authority and, of course, backed up by the government of the state. Now, so they went to court. The people went to court. When she got to court, and the High Court of Lagos State delivered a judgment, now affirming or upholding the position of the school authority that this is not a religious school. If it's a Muslim school, you may be allowed to dress like a Muslim while you're learning, or if it's an Arabic school. But this is a public school where you have pupils from pupils of religious affiliation of Christianity, Islam, traditional religion, and maybe pupils from homes where they do not believe in the existence of any God. Now, having said that, then the pupil appealed to the Court of Appeal. The appeal took an interesting turn. So what the Court of Appeal did is, the Court of Appeal first identified that what the pupil was doing by wearing hijab to school was an exercise of a religious right, both a right, a freedom of religion and freedom of expression. So they are fundamental rights. So which stand beyond or above every other right. One. Two, the court now noted that by pursuant to provision of Section 45 of the Constitution, for rights are not absolute. So those rights can be limited. But before they can be limited, the first test is that the limitation or restriction has to be by a law. A law. So the court now investigated what was even the source of the restriction of the right, while an hijab wearing pupil cannot wear hijab on a uniform to a public school in Lagos State. They realized that the source of that restriction was a directive of Lagos State government. So I'm asking this assembly of experts this question: is a directive of a governor a law? Yes or no? Directive of a governor, is it a law? Yes or no? Please, can I have that answer to that question? Is somebody attempting that? Hello? Hello?
Yes, sir. I didn't hear you, sir.
I said directive by a governor of a state, is it a law? Yes or no?
Sir, I have two approaches to that question.
Oh, yeah.
Can you hear me, sir?
Go ahead, go ahead.
I have two approaches to that question. One is, if the directive by the governor is coming, maybe let's say a particular authority or a particular law empowers him to give that directive. Can you hear me, sir?
Yes, yes, I can hear you.
If a particular law authorizes him to give that particular directive, then that particular directive is a law because it's acting according to a law that empowers him to do so. Now, that's one angle to it. Another second angle is that if the order by the governor is to maintain either a peace or a security of a state, then that particular order will be valid.
So, but you didn't answer it with the second leg of your response.
I didn't do what?
I said you didn't really answer it with the second leg of your question, of your response. My question is that is a directive of a government law.
Yes. I explained the first leg, and I said that under the second leg, if the directive by the governor is to maintain, the state security or for peace or to maintain security within the state, then it is a law.
Who can respond to that position? But before anybody responds to that position, let me say this. So, Governor of Lagos State, Governor Babajide Sanwo-Olu just wakes up on the right or left side of the bed, and he says, I think people living in the Korodu. There was this gentleman that made a very comical video. He said in Lagos State there are two people, living things and non-living things. If you live in Lekki, you are a living thing. If you live in Ikorodu, of course, even if they could not finish. So let's say Mr. Governor, waking up on the left side of the bed saying, people in Ikorodu, I think they are not living. So anytime from 7 p.m., you can't afford to go out if you live in it because people there appear to constitute threat. So that's a directive. And what are the differences between a directive and a law? That a law takes on a journey that subject is to public scrutiny, aside the scrutiny of legislators. And at the end of the day, it gets to the table of the executive, whether the governor or the president, who assents to it or who may veto the bill. So one of the beautiful things about a law is that a law weathered storms. It is tested, it is tried through the process of making, unlike a directive, which is what Mr. Governor can just sit there and just write it. So, but to actually shorten our journey, the truth here is this. The Court of Appeal found that directive of Lagos State government cannot be law because it is not law. And just like I took time to explain now, if you remember the couching of the provision of section 45 of the Constitution, it says a law that is reasonably justifiable in a democratic society. So it is readily an instrument that goes through a journey of trials and tribulation by legislators, members of the public, civil society, the media, that can actually have similarity or can have a semblance of a law that is reasonably justifiable in a democratic society. Unlike a directive, it's just a piece of a document drafted by some person and signed by the government. So now what the Court of Appeal decided is that, look, this restriction failed the first test because it is not a law within the context of the Constitution. So now, when you look at that position, you realize that even before you can limit any right, it has to be limited by a law. While I will agree with, I think it's Chiravi that said, now if that direct is issued pursuant to a law, yes, our courts have actually decided that.
So I was actually the one that said that. It's Michael.
Oh, Michael, thank you. So that if it is issued pursuant to a law, then it has the force of that law. But what we are saying here is that if all you do is to sit down within the confines of your office as a government, and because you consider persons living in the code, you are not living, and you now sign a directive, then that directive, particularly if it is to limit or restrict fundamental human rights, then it cannot actually stand the test of motivation. So that is the position about that. So when you look at it, now, to let me now echo it, no rights are absolute. Do we all agree to that? Do we all agree that no rights are absolute? Hello? Hello, gentlemen.
Yes, sir, we can hear you.
I said, we all agree that no rights are absolute.
Yes, sir.
Okay, great. There's a matter at the Supreme Court right now, and the Learned Council leading the team of legal juggling. You know, I was privileged to read his brief at the Court of Appeal. And he argued that right to freedom of religion is absolute. I said, my Lord, my God. Because I see, when he did that, he actually gave himself so cheap to the opposite counsel, which is the government. You know, I mean, the opposite counsel represented the government right now, because to them, they know that no right is absolute. What he would have done for himself is to, in his own brief, admit that I know that this right is not absolute, like any other right. But then, limiting or restricting this right has to be in due accordance or in consonance with the provision of Section 45. It has to be by the law, and that law has to be reasonably justifiable in a democratic society. And it has to be in pursuit of some objective, which include national security, public order, public health, public morality, and all of that. About 8 of them are listed in Section 45. So, and the same, when you look at it, what Section 3, subsection 2 of NDP has done, it says subject to the position of section of chapter 4 of the Constitution. And of course, position of section 3, subsection 2 of NDP, then your rights, your personal data rights are not absolute. They can fly to any altitude as long as they do not run, contrary to chapter 4, parallel section 45 of the Constitution and section 3 to A to E of the NDP. So when you now look at NDP, so when you're working on it, first of all, check your section 45 of the Constitution, then come down to section 232 A to E of the NDP. Number 1, carried out by a competent authority for the purposes of prevention, investigation, detection, prosecution, adjudication of the criminal offense, or the execution of the criminal penalty in accordance with any applicable law. You and I know that our right to personal data are protected by NDP and even the Constitution. But this section 32A, he said, look, if for whatever reason, the government has to prevent commission of a crime, or they are investigating Genga, or is it Michael now that has to be investigated? So it means they can violate his rights under section 36 of the NDP, pursuant to section 32A of NDP. 32AB, carried out by a competent authority for the purpose of prevention or control of a national public health emergency. This is apt. So let me give you an example. During the COVID era and just shortly post-COVID era, if you are traveling out of Nigeria, you will have to procure or produce at the airport, at the front of body, your COVID vaccine certificate that shows that you have been fully vaccinated. Now, and when you do it, then they will have to scan it to ensure that you actually were vaccinated. Right. So what does that, will somebody actually attempt to look at that? Does that look like a violation of your right to privacy or personal data? Yes or no? Hello? Hello? I think I've lost you guys. Hello, can you hear me? Can you hear me?
Yes, I can hear you. Can hear you.
So I gave an example. Did you hear the example again? Oh, I can even see somebody responded, said it's an exemption to the right because it's for public interest. This was said by Olubusayo. Olubusayo, are you still in the room? Olubusayo. Yes. Did you respond to the example I gave about screening your COVID vaccine certificate? Okay. So well, I would have preferred if you can use your microphone to speak because you are responding to me. Okay, your background is noise. Okay, I can understand. That's okay. So Olubusayo is saying it violates. Anyway, I think he or she jumped. Olubusayo, please let me know. Are you male or female? Please. Female, thank you. So she jumped straight to exemption that look, this is qualified, this qualifies as an exemption. Now, though there's still an issue around that, maybe some other day when we have to discuss, I will tell you how you can, but then it's clear. You need to be sure that look, is it reasonably justifiable in a democratic society? So now, and that's actually one of the things, what is it called? Section 32B of the NDP. It says if it has to be for the purpose of prevention or control of a national public health emergency. So the next one is if it is carried out by a competent authority as it is necessary for national security. Later in practice, many of us will come across and have to deal with the use of national security as a guide to violate right to privacy and other fundamental human rights. If I can tell you that, and let me retrieve or get the opt-in check. Government is the biggest violator of rights all over the board, including the United States. And of course, one of the easiest tools they use for violating these rights is national security. Oftentimes, that thing doesn't mean anything. You should mean something in application. But oftentimes, in the real sense, when it's used, particularly in emerging democracy, it means nothing. When the government just wants to violate your right, all they will do is to cite national security. Now, so let's go to D. In respect of publication in public interest for journalism, educational, artistic, and literary purposes, to the extent that such obligations and rights are incompatible with such purpose. This is what this simply means. That ordinarily, when you want to carry out any kind of process, you have to bear in mind the rights provided and protected under Section 36 of the NDP. Now, but you say, look, if there's a publication that is made in the public interest for journalism, education, art, or literature, that such situation will exempt the data controller from complying with data subject right. And there are many examples that can come to your mind. If there's a particular media release, let's talk about investigative journalism. Michael.
Yes, sir. I can hear you, sir.
If there is a particular citizen of the country that is suspected of funding terrorism finance.
Sorry, you said sponsoring.
Sorry?
You said sponsoring.
Yes, if it's funding or is caught in terrorism finance, okay?
Yes, sir.
Now, Chiremi leads the legal department of one of the biggest media companies in the country. And while his team have been working on investigative journalism, a piece of investigative journalism trying to uncover the man's role in terrorism financing in Nigeria. And also, should now reach out to you that, my friend, what do you think? I mean, I know I trust your expertise, your knowledge in this area. Do you think we can proceed to publish this story with the personal data of Mr. ABC included, his phone number, his bank details, all of these things that we will be able to access? Do you think we are within law? Do you think we are not running contrary to the NDPA, NDPR, and the what is it called, and the Constitution? What would be your advice?
So I didn't actually get your question very well, sir.
So let me rephrase the question. So Chirami is the head of the legal department of a leading media company in Nigeria.
Yes, sir.
An in-house team in his organization is working on a piece of investigative journalism that uncovers terrorism financing in the northern part of Nigeria. And a particular big wig in the society is fingered in that story. And the story contains some of his personal data, including his phone number, his email address, his bank account details, his BBN, his NIN. So Chirami reaches out to me that, okay, Michael, what do you think? My team is about to publish this piece of investigative work. Do you think we are running contrary to provisions of NDP, NDPR, on the Constitution, or we are on a safe foot? What do you think? What will be your advice?
Well, what I would say here is that if the media house headed by Chirumi, their investigations are actually true, like they actually have facts that if such matter will come before the court, they'll be able to place those facts and they can actually, the court will agree with them.
Don't go to court here. Don't go to court. You see, if you listen to my position before that, what I've done with that story, with this hypothetical story, is to to illustrate provision of Section 32D. So I want you to look at, did you read what is in, you know what is in 32D? Should I read it for you again?
I'll be happy if you do that, sir.
Now, this is where instances where, okay, let me start from Section 3A. Now, 3 says, this act shall not apply. Are you listening?
Yes, I can hear you.
To the processing of personal data carried out by one or more persons solely for personal or household purposes, provided that such processing for personal or household purposes does not constitute violation of fundamental right to privacy of the data subject. Let me now come to 2, subsection 2. Subject to the right and freedom under the Constitution and the limitations, the obligations under Part 4, other than Section 24, 25, 32, 40 of this Act, shall not. So let me help you again. Subject to the right and freedom under the Constitution and limitation, this right shall not apply. In fact, not this right. This Act shall not apply to a data controller or a data processor if the processor of personal data is, let's go to B, in respect of publication in the public interest for journalism, educational, artistic, and literary purposes, to the extent that such obligations and rights are incompatible with such purposes. Did you get that?
Yes, sir. Yes, sir. I got you, sir.
So what's your advice for children?
I would advise them to go ahead, sir, with the provisions you just read.
Michael. Okay, so let me give you an opportunity. Why did you say so? Why do you want him to stick at it?
Because
Francis, I will call on you in a minute.
Hello.
Yes, I can hear you. Go ahead, Michael. Okay, Francis. Francis, can we have you?
All right, sir. I think that for me, I would say that it would be a violation of the Nigeria Data Protection Act if they proceed to publish personal details of the bigwig that are not necessary for the purposes of the journalistic piece itself. For instance, publishing the person's BVN, phone number, address, those things do not necessarily say anything. They are not directly necessary for informing the public about the terrorism financing connections of that person. So it would be a violation of data protection principles.
Mr. Francis.
Yes, sir.
Okay, so now if I'm sure you need to really have the situation in perspective. Francis, this is terrorism finance. Now, money is moved from one account to the other. That account has a BVN. It has a BVN, it has a phone number, it has an email attached to it, it has a residential address attached to it, or a corporate office attached to it. So how do you want to convincingly tell the public that, look, this person is responsible for terrorism financing in the northwest of Nigeria? Now, when all you want to do is just send to the public, I mean, just publish that, okay, his account, and we figured that Mr. Oluwagbenga, is involved in some terrorism financing in another part of Nigeria and all of that. So do you think you can do justice to your story when what you are publishing is an investigative work on terrorism financing? Francis, please answer that.
Okay, well, like you said, I'm just getting the proper context for the story. I think that yes, it will be necessary in doing justice, like you said, to the story, to connecting the bigwig, so-called, to the terrorism financing issue or incident. So yes, I think that's.
So in that case, you advise Chiremi to go ahead.
I would advise him to go ahead. Yes, because it's in the public interest.
Some people want to cut your neck. So when they launch suit against him, so should he come to your office?
Yes, sir.
Okay, so Chukwemeka, I'm going to call on you, but before then, so what would be your defense? What defense do you think Chiremi's company has in law? Okay, I think Francis has gone to take some coffee. So Chukwemeka, please, let's have you.
I'm good, sir. Can you hear me? Hello, can you hear me, sir?
Clearly.
Okay, so going by what you said, and I also read the Act section 3 sub 2D. I'm not mistaken. For the work that Shoremi wants to do, which is investigative journalism, and the fact that what she wants to publish is something on terrorism financing, I would say she should also publish. But where I would cut her off is that she shouldn't publish details that, how I put it, she shouldn't publish the big wigs person, that BVN that she has led her to discover something like we discovered from what we checked. We discovered that sounds. Yes, sir. The BVN is not published, but she can publish
that identifies the account.
Yes, if those ones, she can actually use a pseudonym for the BVN.
No, I'm not going to answer that question. Chiremi, are you still in the room?
Yes, I'm here.
Do you agree that not publishing BVN in the story of terrorism financing do you think you'll be able to, effectively link? I'm just asking a question, please, and don't be persuaded by the tone of my voice. Are you sure Nigerian people will be persuaded that, look, this man, because to me, BVN is actually your most important digital identity when it comes to your banking details or banking transaction. It's identified more than another. So what's your position? Will you advise your team to include BVN or they should exclude?
I would advise my team to exclude the BVN. That's my opinion.
Hey, you would you have inside the fear?
No. Because as you said, it is the most important piece of the
You
digital
said they should
identity
exclude
for
it. They should
banking.
remove it, Abby.
There's a way they can convincingly, like the account numbers can be traced here, they can be linked, but I think that BVN
Okay.
should be kept
So I
aside.
think Abibola has a thought. Abibola.
No, sir, I don't, sir.
Okay. But even when you don't, you need to have a thought now. So what do you think? You think the BVN may be necessary to be published alongside the work?
So honestly, I don't have any ideas, sir.
Are you fine? Even your voice does not tell me that. Are you fine?
I'm not really feeling fine. I'm just.
I'm sorry about that.
Thank you, sir.
Which group are you?
Group 1.
Group 1. Who is the presenter or the leader for group 1?
Mr. Mr. Akinde.
Okay, please, the group leader or the presenter, please get Abimbola a cup of hot coffee tonight, and I want a report next week Saturday. Is that clear? I have witnesses in the house. Hello.
Hello, sir. Yes, sir, you do. You have witnesses, sir.
Yeah, I have witnesses. Thank you. So a cup of hot coffee for Abimbola. So, and Abimbola, if the residents of the, what is it called, apart from yours, don't worry. Just get a cup of hot coffee for yourself. Then the group will reimburse you whatever the value of that hot coffee. Is that clear?
Thank you, sir.
There's no money, sir.
Oh, no, I don't want to hear that. All of you are big men and women making money. When it comes to buy coffee, you'll be giving us. So that's it. Now, somebody raised up Victoria. Victoria, why not? Don't leave
I'm
me.
here.
Yes, raise your hand.
Yes.
Yes, let's
so I just wanted to say, yes, maybe, can you hear me, sir?
Clearly.
Okay. Yes, they are a publishing company, and they are pushing for for terrorism. Well, yes, they can enlighten the public that these certain persons are actively involved in terrorism, but I don't think they are in the position to release those key details about these persons, because they are in the position, they are not the ones who the law have to right to disclose information. So I believe that there are certain institutions in the law that are in charge of processing data for security purposes. So maybe if they are able to find out this detail, they can pass it on to those persons who the law have empowered to do such.
Okay, so Victoria, do you engage with investigative journalism regularly?
Well, there is this guy on Twitter, David Hundeyin, he does investigative journalism.
Well, so David Hundeyin does it. Fisayo Chuyombo does it. Those are here. I mean, this babe also does it. Kid Cody, you know, and there's some other work investigative journalists. Look, when investigative journalists, the whole idea of this exemption is to protect investigative journalists and to actually preserve the right to hear or to know by the public. Look, between you and I can tell you, even the government, even the security institutions, there are times that they will not have access to some information.
Yes.
Did you have you heard of Snowden? Edward Snowden?
No, sir.
Please just check that story. Just check that guy out. Not just check him. I'm going to refer you and all of you. Please, I want to refer you to Global Freedom of Expression. Global Freedom of Expression.
Mr. Solomon.
My God.
Solomon, please. Hello, Mr. Solomon.
Yes, my God, I can hear you.
Please, with your kind permission, I have a little contribution on this very aspect. Very interesting.
Please, my God, please come in.
Thank you very much. I would like to share a case of the Grand Chamber of the European Court of Human Rights that ruled on something similar like this. And I believe that this case will actually give a clearer understanding on this very aspect. Now, in this very case, a journalist took before the appeal, let me just in the trial court, he actually was restricted from publishing a report of an actor that was convicted for drug-related activities. Now, on appeal, he now went on appeal that this is actually his right to expression. So he cannot be restricted from publishing such article. Now, in determining this very case, the court was very smart to look at the fact that, does this affect the privacy of the other person? Now, in determining this very question, the court now asked another question. Now, when it comes to privacy, data protection, whatever, it is very essential to look at the fact that it must be okay, let me use Mr. Solomon's word, essential for a democratic society. It must be something that must fit into a democratic society. So the court had to examine certain articles of the Charter on Human Rights, and the court, in its wisdom, now went further to explain that the rights to freedom of expression must be construed strictly, and the need for any restriction must establish convincingly that, in particular, okay, sorry, let me just get the context and bring it out. Okay, good. The court held that, in particular, the court noted that the press and the media have an essential role in a democratic society, and that they have a duty to impart information and idea on matters of public interest. This duty extends to the reporting and commenting on even court proceedings. So this was a decision now. They really held strong to the fact that a democratic society requires press and their function. Now, there's something interesting again that the court looked into again. Let me break that aspect down. Now, this very person that was convicted for drug-related activities is actually an actor who is a public figure. So immediately the matter came up, everybody was interested in the matter, because he is actually in the limelight, and his details are in the public. So the court now asked another question, that if this very person was a private figure, then they could have considered his rights to privacy.
Yes.
But having the fact that he is actually a public figure, and the public they are so interested in his matter because it's of public interest.
Thank you, Mr. Emmanuel. I wanted to pause. So it is because if it was Victoria is a brilliant lawyer who lives a life as a private citizen. But if it is Governor Victoria, the rule changes, right? Mr. Emmanuel.
Yes, I'm with you. Yes. So
I'm sure that's what you were saying, sir.
Exactly. So the court was now looking at it that, okay, let's say he is a private person and he is trying to protect his reputation. Then it would be fair to say, yes, let us consider his privacy. But on the other hand, he's an actor, he's a public figure. People have interest in his matter because it is of public interest. Then there's no way they can restrain the publisher from bringing out such information to the public. So let me just hold on here. I believe that this case is actually a clear position to explain better on this.
In fact, I have quite a number of cases on that. And let me also just bring this up, that if we're going to have any hard nut to crack, it will be what qualifies as public interest in particular circumstances. Now, what qualifies as public interest in terrorism finance? Victoria, do you agree that any story of information about terrorism finance in Nigeria, will you consider such to be of public interest? Yes or no?
Yes, terrorism financing is of public interest because it affects.
Okay, good. Now, will you consider financing? Okay, so let's pick two issues. Now, there are two gentlemen, Mr. Richard and Mr. Colbert. The two of them live in Banana. The two of them bought the same piece of land beside, equal parcel of land beside each other. They built the same house at the cost of $10 million each. Now, so and the story of building of that house by Mr. Richard has actually been of public interest. Now, so a journalist, can you hear me?
Yes, sir, I can hear you.
A journalist wants to publish an investigative journalism, on a piece on the story of $10 million house by Mr. Richard, which story will include some of his personality. The other guy wants to publish a particular story about terrorism financing about Mr. Colbert, not about the house by Mr. Colbert. So will you advise the two journalists to go ahead in two instances? And if not, which one would you advise to go ahead, which one would you not go ahead, and why?
Well, sir, I'd advise the one that relates to the building of the house first, because this is my reason. Because this guy is a public figure.
Do what? No. Mr. Richard and Mr. Colbert are private citizens.
Oh, okay.
The two of them are private citizens.
Okay.
The two of them built houses. Each of their houses is worth $10 million. So, but Mr. Richard, a journalist tried to do a story of Mr. Richard on that house, the figure, which includes some of his personal details. how he raised his money and all of that. Then another journalist is about to release a story about terrorism financing on Mr. Colbert, not on his own house. They are two private sectors. So what would be your advice to the journalist?
Well, I'd advise him to publish on
There are two different journalists.
On terrorism financing, the one who is to publish on terrorism financing, because the article about Mr. Richard is on his private life. It's not of public interest. The public, it does not affect the public how he spends his money. But one on terrorism financing, it affects the public, because if this terrorism is financed, the public will eventually be at security risk. So if that the information of terrorism financing is more of public interest than that of personal respect.
Does anybody disagree with Victoria? Does anybody disagree with Victoria? Hello? Guys, I know that the day is fast spent, and yes. So I'm asking, does anybody disagree with Victoria? Can you hear me?
Yes, I can hear you, sir.
I'm asking if anybody disagrees with you. Okay, so Olubusayo said I agree with us. Okay, that's fine. And for the record, let me ask, how many of you here have laid your hand on decision of the US court in Chicago, in Atiku Abubakar and Chicago State University?
Sir, I've not been able to read the actual transcript of the judgment, but I have some understanding of the final
What's the
decision,
understanding you have?
Okay, well, I understand that the deponents, the judge ruled that Tinubu's records can be accessed, should be opened up for access to Atiku's legal team.
That's in there. I mean, everybody out there will know that you are not taking a position like every man on the street now. You are taking a position as a professional, as a privacy expert. Are you aware that Tinubu raised an issue of privacy?
I wasn't aware, sir.
So you raised it, and of course, the court looked at that. The court even stated that Mr. Atiku Abubakar has a significantly heavier body on him that he has to discharge, since Mr. Tinubu has raised an issue of privacy. But the court also now looked at it, that look, Mr. Bola Ahmed Tinubu is a public figure, the president of the federal government. Is someone whose record, it's even a subject of not only the election conducted in Nigeria, but it's actually relevant. I use the word relevant in determination of the election petition proceeding. Well, for any of you who doesn't have it and who is interested, in less than 2 weeks from now, go to Columbia University Global Freedom of Expression. You will read our analysis on it, and you will see all the judgments, both at the First Instance Court and the Court of Appeal, and all the filings by all the legal teams.
All right, sir.
Yes. So, gentlemen, I think there is fast spent, and I don't know, Mr. Amanda, you really have to forgive me. because I really don't know what you have left my organ now. The part that I've taken most of the time, and I don't like being the first person to speak because I get to throw myself into it. Now, the last thing on section 3, subsection 2 says, if it is necessary for establishment, exercise, or defense of legal claims, whether in court proceeding or in administrative or out of court proceeding. So when you look at the case of Atiku Abubakar and Chicago State University, it falls under essentially E, which it is necessary for establishment, exercise, defense of legal claims, whether in court proceeding. Because Mr. Atiku Abubakar is saying this information, the discovery is necessary for determination of the election, presidential election dispute between himself and INEC and Mr. Bola Ahmed Tinubu in Nigeria. So the court considered it, but the court didn't just stop there. The court actually weighed heavily on the issue of the fact that that discovery is in the interest of the public, of the Nigerian society. So, like I said, essentially, in about 2 weeks from now, when you go to the Global Inspection of Columbia University, the City of New York, you will read our analysis, of course, and you also read, you'll be able to access the judgment of the First Instance Court, of the Court of Appeal, and of course, of all the filings by the legal teams from both sides. So, gentlemen, I think on this note, I want to say I will step back, and it's 7:23 already. We spent the whole lot of time. So thank you for your time. And I will still stand by if there's anything I need to respond to. I just think the day is done. So thank you, guys.
Thank you, sir. Great, insightful discussion from you, sir.
Yes, it was indeed truly a very insightful and detailed, well discussed, full of vast knowledge on that subject matter. We still have Mr. Emmanuel. I want to also plead and thank the nurses for their patience and being on through the whole call. So I'd like to call Mr. Emmanuel if he still has his contributions on this matter. Sorry, the floor is yours. You can give your contributions and then we'll just take the little questions and we'll call it a day.
Okay, thank you very much. And thank you very much also to Mr. Solomon for that insightful section. And I will not want to take much of our time because we just have just few minutes to go. So Group two presenter Oluwabenga, you were talking on negative, positive, right? And I think I would like more clarity on that, so that maybe your group discuss something like that, so that we can actually correct something. Please give us the clarity on what you mean by negative right and positive right. Is Oluwabenga here?
I don't think he's still on the call.
Okay, Group 2.
Or is there anyone from Group 2 who can help with that clarification? Okay, anybody from Group 2 can help us with that clarification? Since we don't have anyone from Group 3 that is still left on the call.
Okay, so maybe we can take this another time. Nevertheless, the right to a data subject is something very, very easy to understand, and from the presentation, from their work as well, I can say that everything is well understood by both groups. And I like the fact, as Mr. Solomon mentioned, I like the fact that they made references and to case law and also and to the law as well. So I think we have a great touch of it. No need to waste our time. We'll have a wonderful section next week. So maybe we can take questions Thank you very much, Mr. Dennis.
Yes, sir. Thank you so much, Mr. Emmanuel. Thank you for speaking and staying around and also joining us. We'll be taking questions. Okay, I can see Victoria raising up her hand. Victoria, you can quickly go ahead and ask your question.
All right. Thank you very much for this opportunity. Solomon. So, Mr. Solomon, this week, this section, section of communications regulation, and it's understanding that the Nigerian data protection is protecting the privacy of individuals. It now gives the rights to like invade people's privacy, the sake of public interest and all that.
Sorry to cut in, Victoria. It seems your network is bad. We can't. I don't know if it's just me, but we can't really hear you.
Okay. Okay, so can you hear now?
It's still a bit bad. Can you send in the question into the chat box so that we will read it?
Can you hear me
now? It's still not so clear. All right. I'm sure she's trying to work on the questions and she sent it in chat. But is there any other person with a question? So I'll wait for her to ask a question. Do we have any other person with a question on the topic for today? Okay. Victoria, are you still with us?
you hear me?
Yes, it's better now.
Okay. I was saying that in research came across the law came to understand that while the NDPA is protecting the privacy of individuals, government to invade people's communication and access certain information. So my question is to Mr. Solomon, what is the thin line between invading people's privacy for the sake of security and protecting people's privacy under the law? Because I feel like this act may be at some point clashing. I don't know if it's just my thoughts. So that is the question.
No. Okay. Can you hear me?
Yeah, hear you, sir.
Yes, sir. Yes, sir. So,
which act do you think NDPA and which other instruments are you saying that will be classic? What do you know?
Section of Communication Regulation 2019.
I didn't get that. Please say that again.
Lawful interception of communication regulation.
Now
it was made. Yeah.
So can you hear me?
Hello?
Now? Hello, can you hear me?
Yes, I can hear you.
Yeah.
Yes.
Okay, good. I think it's clear. So when you now the position in the lawful, whether it's the lawful communication regulation or the chapter 4 of the Constitution or NDP, what we are saying is that they can only be limited in strict conduct with the position of the law. So let me give you, okay, somebody wrote something. Okay. So it's still Victoria. So the position here is this. For example, look at the cyber crime act. It's section 38. It allows the government, particularly the security agency, to violate people's privacy or detection, investigation, prevention of prosecution of crime. Now, so you are saying there can be clashing, there can be conflict. Now, what I mean clashing or conflict now in process of national security and prevention of protection of privacy. I have said
Yes.
it over and over. For example, in Colombia has a center, a whole center on national security and privacy. Because privacy is a big issue, number one. And number two, because national security is the fraud that the government uses to violate people's rights most of the time. So, but what we are saying is that in any situation, the government cannot just wake up and should not just wake up someday and say, look, for the purpose of national security. So the Nigeria's Digital Identity Project, the NIM project, I happen to be the lead consultant that worked for the development partners, the trial of European Investment Bank, World Bank, and FDA on preparing a human rights impact assessment of the project, focusing on data protection and privacy. So while undertaking the project, we had reason to consider the data protection bill 2020. Now, so what data protection bill 2020, which is still not far from what is it called? From what how do I put it? So okay, so comparing it from, yes, I think I missed myself. Comparing with data protection bill 2020, what we have done, all it provided was that in cases of national security, public defense, public safety, issues of data privacy shall be exempted. Shall be exempted. Are you following me, Victoria? Hello, Victoria. Hello? Can you hear me? Can somebody hear me? Let me know that I'm still being heard.
Yes, sir. You're audible. I don't know. Maybe it's from Victoria's answer.
Yes,
Okay.
sir. Yes, sir.
Okay, thank you. So provision of section 35 of Data Protection Bill 2020 was that in any event of national security, national safety, public defense, principle of data privacy shall be exempted. That was too broad a blanket exception. In fact, that provision was going to make a mess of everything about data privacy if that bill, became an act. But of course, we strongly, singled out among others to the claim, which this time around was European Investment Bank, leading the trial of EIB, World Bank, and FD. That look, if this bill becomes a law with this provision, then we are all here joking. Now, because at any instant, all anybody needs to do is to have a relation with the national security, state security service, and the person will just say, will just be demand to access personal data of all lawyers in Lagos. And all they will do is they just say for national security. And because they have cited for national security, even NIMC will have to comply. They can't check anything. But let us look at what section 3 has done. Section 3(2). It says, subject to the right and freedom under the Constitution and the limitations, the obligation under Part 4. So he's not saying what he now did there. It's in fact the way the recommendation we made for EIB, the Nigerian government have actually applied it, directly or in substance. It will even be better than what reflects in this section 3 subsection 2. But in any case, this section 3 subsection 2, by inference, is still better than section 35 of Data Protection Bill 2020, which says in any case to just cite national security, then the principle of data privacy shall be protected. There's nothing called privacy. But with this one, all you need to do is to say, look, yes, while I know that you can limit my privacy, you have to do that in due and strict adherence to provisions of section 45 of the Constitution as contained in chapter 4. So you have to look at what is that provision. Section 45. It says it has to be by a law. That law has to be reasonably justifiable in a democratic society. But however, let me say why this is not detailed enough with that. Before, all anybody still needs to do under section 32C is to say this is necessary for national security. Victoria.
Sir, I can hear you.
In that system, who will determine what is necessary for national security?
Well, the law and the government.
Yes, the government that will determine with this, as it is couched, it's this provision. But now imagine the way we couched it for them, the recommendation, they are subject to clear constitutional safeguards, which will include, for example, if you need to violate people's privacy because there's no kind of security, we recommended that the security agency involved needs to get an affidavit, try to an affidavit, then prepare a motion, bring motion. It's okay to be a motion expert. Bring a motion expert before a court. Let a court give an order for you to violate that privacy. You get the point?
Yes.
We are saying it is not just enough to say that SSS can say it's because of it's necessary for national security. Who determines what is necessary for national security? It is only the party that is implementing that position, that policy. But the moment you introduce riders, conditions that are subject to clear constitutional safeguards, it must be subjected to some safeguards. So basically, so that actually shows that we really need to keep, working hard, keep be on the toes of the government. There's another side to some of these laws. Yes. Maybe when we are in last atmosphere, I will share that with you. It's not all the time that the government enacts a law because the law keeps. Don't worry. So does that answer your question, Victoria? Hello, Victoria. Hello.
Victoria, are you with us?
I'm not sure she with us anymore. But basically, so answering that question, I'll be able to say that look, in implementing it, the lawful interception, it has to be subject to constitutional safeguards. It cannot be arbitrary. So if we have a law or implementation of a law that makes it look arbitrary, then of course it cannot work. One example I would love to give is the case of Facebook and AG New York, where AG New York served what is it called? Served a warrant of a search warrant on Facebook that they wanted to search the details of 185 Facebook accounts. And Facebook went to court. They said, no, you can't do this. Look, yes, we know you have produced a search warrant, to search an account, a Facebook account. But look, we are, first of all, a global landlord to all of our subscribers all over the world. And we owe them fiduciary duties. Beyond that, we need to establish that if you were going to search 185 houses in the physical place, you cannot do that with one search warrant. So because there's element of particularity about each search. So you want to search Victoria's house, is it the same thing that you're looking for in Victoria's house that you're looking for in Mecca's house? So each of them, you need to produce search warrant for each of these persons. And of course, the court ruled in favor of Facebook in that case. So when you look at it, that is actually one of safeguards. There must be safeguard. There must be. There must be. But I can assure you, if the way we run in our society, if State Security Service, writes NIMSI today, forget everything that they will gladly oblige. I hope that makes sense to anyone. So I made my points. I hope I answered Victoria's question. Facebook and AG New York. Facebook and somebody has a question. Facebook and AG New York.
All right, thank you very much for answering that question. I want to also thank Mrs. once again for still being on call, making sure that we follow through with everything that Mr. Solomon has to say. Mr. Solomon, thank you so much once again for this very, very wonderful and insightful section on data privacy and data subject rights. I'm sure most of our mentees here are lawyers, and this topic may not necessarily be alien to them, but I'm sure they must have learned a thing or two in this line that they must have not known prior to this class. And I really want to thank you, sir, for sharing with us some of your large insights into this topic. Thank you once again, sir, for always checking in when we call. We really appreciate your efforts, sir. Thank you so much. Hello, can everybody hear me? Hello? Hello?
Hello, sir.
Yes, sir.
Hello, can anybody hear me?
Yes, sir, we can hear you.
Okay. Okay, Mr. Michael, it seems like you have a question, right?
Yes, I just wanted to ask Mr. Solomon the progress on his case at Federal High Court here, in respect of the court that has jurisdiction, in respect of data privacy and protection in Nigeria.
Okay. So what as at can you hear me?
Yes, I can hear you, sir.
As at 2 days ago, it had been assigned to, it was eventually assigned to a court, my Lord Justice Ekpo, at Court 7 Abuja. And we are yet to get a date. So we hope we get a date this week. And we should also, when I mean this week, maybe by November, we come up in November. And before then we'll serve because you don't serve at the Federal Court, you don't serve what is it called? The respondent or defendant until a date is fixed. So when a date is fixed for the matter, then they will serve the respondent. So when we serve the respondent, we hope they show up. If they don't show up, let's look at early February next year. If the law can give us late January, we'll be glad to come to court. So I'm actually quite excited about the case. I'm optimistic. I'm looking forward to what my Lord will say. So because we are saying this is a situation, a pending chaotic legal adjudication, where somebody can say, yes, why can't I go to magistrate court? Why can't magistrate court attend to it when the person involved is in fact, some cases have been filed at magistrate court as I speak to you. So, so we need to be sure of what we are doing. But the most important thing and exciting thing for me is that the interpretation section 65 uses that any court of competent jurisdiction, our courts have answered and have defined what court is a court of competent jurisdiction. It says one, it must be a court that is duly constituted. If it's a one-man court, one-man bench court must be, that judge must be present. If it's a three-man bench court, then the three judges must be present. If two judges are present, it doesn't have competent jurisdiction. Number two, the court must have subject matter jurisdiction. Subject matter jurisdiction. So, and it says, look, subject matter jurisdiction is not by party, nor is barred by the court. It must be a matter of express provision by the Constitution or an act, a statute. So, and number three, there must be nothing that prevents the court from exercising jurisdiction. Maybe the party doesn't have locus standi. So look, it is not just to say any court of competent jurisdiction. Of competent jurisdiction will be, this law needs to identify courts with subject matter jurisdiction on data protection. Saying any court of competent jurisdiction, it's just say nothing. Because even if we can tick the first box of constitution of the bench, we can tick the third box of local standi, for example. How can we tick, confidently tick the second box, which is subject matter jurisdiction, which is what can only be dominated by the Constitution or law? Yes, I think Michael wants to say something.
Yes, sir.
Yes.
I don't know whether that would be right to ask you of your prayers before the court, like the things, the kind of orders you want the court to give in respect to this matter.
Okay, so let me try to see if I can access. I think I have about 8 prayers. Let me see. Okay. So yes. So the prayers to the courts are one, a declaration that provision of specific courts with subject matter jurisdiction to adjudicate on data protection and privacy related subjects in the Nigeria Data Protection Act 2023 is fundamental to the fulfillment of the objectives of the Nigeria Data Protection and protection of the personal data and privacy of the applicant. Now, what that simply says is that providing a court with a specific court with the subject matter jurisdiction is fundamental to adjudicate on data protection and privacy under this act is fundamental to the protection of my right to privacy and personal data. That's the first relief, which is a declaration. The second relief is also a declaration that the definition of court in section 65 of the NDPA as any court of competent jurisdiction without first specifying the court with the subject matter jurisdiction in the Nigerian Data Protection Act is imprecise, vague, nebulous, overbroad, and capable of resulting in uncertainty and miscarriage of justice. Really, 3, a declaration that the definition of court in Section 65 of the NDP violates the constitutional right to access to justice, as it fails to provide a clear and specific definition of the court, vested with jurisdiction to hear and determine matters related to data protection. What this really is saying that, look, if I cannot know by precision, by the guidance of the enabling law, which court I can seek redress, then it violates the principle of constitutional right to access to justice. If I just assume that, okay, well, since the court, the law does not state the particular court with subject matter jurisdiction, so let me go to magistrate, and I get to magistrate only for me to meet obstacle that it doesn't have jurisdiction, and I will have to come back and I have to guess, should I go to high court or federal high court? Then it actually stands in the way of my right to access to justice. Really, 4, a declaration that failure of the NDPA to specify the court with subject matter jurisdiction to adjudicate on data protection matters under the Act is a fundamental lacuna. Really, 5, a declaration that the meaning of court in relation to the words court and civil proceeding as used in the NDP shall mean at this instance, I now want the court to now interpret, shall mean Federal High Court, High Court of State, and High Court of the Federal Capital Territory. I want the court to fill in the gap for the time being, or in the time being, sorry. Really, 6, a consequential order directing the second respondent, which is the National Assembly, to immediately amend Section 65 of the NDP to provide a clear and unambiguous definition of court to mean Federal High Court, High Court of State, and High Court of FCT. Really, 7, a further order directing the first respondent to liaise, facilitate, and ensure immediate amendment. That is the AGF, liaising with the National Assembly, of course, to make that amendment. And of course, really, 8 is any further or other orders as this honorable court may deem fit in the circumstance of this case, so help us and so help the courts and so help us. Okay, so basically those are the 7 specific reliefs I've prayed the court.
All right, thank you very much.
Is there anything you would love to have added?
No, the point I wanted to make is that you know that issues of data protection, but I think you captured it in your one of the prayers. You know, this is an offshoot of fundamental human rights enshrined in the Constitution, particularly right to privacy.
Yes. So let me now remind you. Are you aware that freedom of information is an offshoot of Section 39?
Freedom of what?
Of information.
Yes.
You know, we have Freedom of Information Act, and Section 39 is, empowers you to access information and idea, to access them. So, but because we need more detailed, specific legislation, subject matter legislation, that we now have Freedom of Information Act for section, out of Section 39, the same thing now applies to Data Protection Act that came out of Section 37. So,
yes, sir.
Freedom of Information Act, now under that law, it provides for High Court and Federal High Court as the court with the subject matter jurisdiction. So why do you think that law was made that way? Even though freedom of information is a matter of fundamental human rights.
Did you allow me to say something?
Sorry?
Allow me to land. Like, you can allow me to say what I want to say.
Oh, sorry about that. Can you speak up? Can you speak a bit louder?
Yes. Can you hear me now?
Yes, I can.
Okay. What I was saying is that I think I mentioned it to you the other time, but I would like to still say it again, because issues of violation of right, the court that has, that's violation of fundamental human rights. The court that has the jurisdiction to entertain such matters are Federal High Court and also State High Court in respective cases. Now, I was thinking that since this particular, right to privacy or data protection is an offshoot of Section 37 of the Constitution, any court in that particular act, mentioned there is the Federal High Court. Since it's an offshoot of, because data protection too is right.
In that case, you know what
no, let me answer.
Okay.
Data protection too is a protection of rights, not different from the ones under the Constitution. Just that these particular rights are transferred, they are extension of protection of rights, but in a digital form. I don't know whether you understand. I'm trying to make it so that
it doesn't have to be digital. It doesn't have to be digital. Data protection, that's another mistake. Data protection, does not apply to it does not apply to digital platforms alone. For example, let me give you an example. You have your complimentary card, you keep it on your table, and I get your table and I slip it into the other of a top part. There's nothing digital in that entire process. Yes, I violated your right to personality. But I have an idea of what you're talking about. So,
yeah, I agree with you, sir.
So please make your point, conclude your point. Let me be able to.
Okay, the point I'm trying to make is that any court used in that act is the court that has the right to entertain issues that has to do with fundamental human rights under the Constitution.
But that law does not say that. Remember what that law said? It said any court of competent jurisdiction. Even the way it said it, any court of competent jurisdiction. So the question you are likely to ask is, now if we will say, now you want us to do what the court has said we should not do, that we should not infer. That's what the court said, the court said we should not infer. So if we are doing that, we are throwing that part, you are leading us. That part is a part of inference. Is that correct?
I agree with you, sir. Let's wait for the outcome of the judgment.
Before the what is it called? Before the judgment will come out. When I litigate constitutional matters, I litigate with the mindset of getting to the Supreme Court. But before we go there, let's even among ourselves, ask ourselves. Now, when you said these data protection matters should be matters of right to privacy, which is even my position too. But I am saying our courts have decided that the court cannot infer jurisdiction cannot infer jurisdiction. This subject matter has to be expressly donated by the Constitution or the law or a particular statute. In fact, you know what I do? Now, at DRLI and as what we do to bring it under to take it to Federal High Court is that we bring it as a fundamental rights suit. Let me let you know this. Do you know that there could be instances where it can be brought not as a fundamental right suit? Check Freedom of Information Act. When you are filing an action under Freedom of Information Act, you don't file it as under FREPL. Are you aware? It has actually taken its own status, own independent status, and it has its own statutes. I get your point, but I'm saying that we should not run a risk of inferring. What we have done so far is that we have inferred. And those of us that have litigated it as fundamental human right, what we have done is that we have brought it under fundamental right, so we have protected it. So it is easy for the court to use it that way. But if you want to be litigating it as strictly under NDPA, then let that law expressly state, not I mean, what does it cost the legislature to say that? That the court, what are they afraid of? Why did they leave that house? Why did they leave it open? That's even the question we should have asked. Why didn't they do what was done in FOI? Why did they do what was done in cyber crime? Why did they do what they did in other acts? Why did they say any court of competent jurisdiction? Why? Because they thought, let us just leave the room. Which room? The living room for chaos and anarchy. That's what I'm saying, that as at now, people have gone to magistrate courts on any other EDP. Will you blame them? Of course not.
Thank you, sir.
So that's my view.
Thank you,
But thank you so much, sir, and thank you, Mr. Michael, for that contribution and the question that you asked. Thank you, Mr. Solomon, for taking out your time to answer all the questions. Are there any more questions, or can we just call it a day?
From my hand, I think I'm calling it a night. Thank you, guys. It's been amazing talking to you.
Yes, same here, sir. Thank you so much for always having our time, sir.
Thank you.
Yeah, all right. All right, so we'll be saying goodbye here. Please do well to, well, I'll be sending in the attendance to the group link. Please do well to fill in the attendance after the session. Thank you very much. And everyone, I wish everyone a lovely night's rest. Take care and good night.